Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the recently passed new apprentice law. To discuss the issue, I have with me Dr. Preet Rastogi, Professor, Institute for Human Development, Avinash Gautam, Advocate on Record, Supreme Court, Mr. J.V. Rao, CEO, Textile Sector Skill Council. Now for the headlines. The new apprentices law enables employers upgraded legal framework to employ apprentices. It allows employers free hand in recruiting apprentices with rights to determine working conditions. It removes penal provisions against the employers, which was being seen as a deterrent by industry. The new apprentice law gives free hand to the industry. It enables them to empower employers to formulate their own policies for recruiting apprentices. The new law also allows companies to add new trades without government approval, as per the need of the industry. The previous law of 1971 stated that the weekly and daily hours of work and leave entitlements of an apprentice shall be as prescribed by government rules. The new Apprentice Act 2014 empowers employers to formulate their own policies for recruiting apprentices. It permits more than one employer to participate in training and employment of workforce in areas of common interest. For example, two textile mills producing cotton yarn can share apprentices, provide training according to their needs. Earlier, only one company was allowed, and if the other wanted similar apprentices, they had to follow a separate procedure.
I think this Apprentices Act gives more scope, power and choices to the employers to hire people not only from their own states where they are located, but also from other states. It increases on the number of vocational trades, like even from the non-engineering staff they can be engaged, and from other courses that have been prescribed.
As per the new law, employers will determine recruitment policy and timing of apprentices. The new law provides for simplifying the procedure for registration of contract apprenticeship training. Syllabus and equipment for practical training modules will have to be approved by the government. It permits sitting in the examination optional and allows certification from any competent agency. It allows for rule-making powers to facilitate recognition of training started pending notification of new trades under the Act.
This step was taken by the government only to please the corporate house, because from the very beginning they are demanding that labor laws should be flexible, and they want more employee on contract basis. No regular employee should be in the factory, and according to this amendment, now they have full liberty to appoint apprentice instead of contract labor.
Unorganized people, especially in remote areas, the provision of working hours I feel should be clarified, and other things should be clarified, that they should be taking number of apprentices, and yes, they should not be making them work for certain, beyond the provisions of the other act, like the Shop and Establishment Acts and the Factories Act.
The Act has changed the definitions of designated trade, graduate or technician apprentice, trade apprentice, industry and worker, to allow apprentice from non-technical streams to acquire training. Law has mandated the central government to prescribe the number of apprentices to be engaged by an employer for designated trade to allow uniformity in hiring.
Government has made provisions to allow apprentices to seek more knowledge and learn more modules when they join any firm. These provisions were not present in the earlier act. Government is hopeful that this will encourage the youth in seeking apprenticeship. With camera person Rajdeep, Rajkamal Rao, Rajya Sabha TV.
The outgoing government had introduced the bill, which has now been approved by the incumbent government. Ma'am, straight away the first question to you, ma'am. Allowing a free hand to the industry, which the industry really was wanting in this matter. How do you see this change impacting the people who want to take advantage of apprenticeship?
See, the first thing I would say is, given the surplus labor condition we have in our country and the fact that we have a high level of unemployment or disguised unemployment, we need to have skill and training. And if the Apprenticeship Act actually gives avenues for people to get skilled, which is the main objective, then it will actually serve a very good purpose for the workers. But having said that, it's also equally important that the firms and the corporates or the industries that are going to be taking up this apprenticeship should actually have an objective of training them in a manner so as to get them employment eventually. If it is going to be used only as cheap labor, which tends to be a case in most cases, then it will be a real concern and an issue.
Avinash, do you think it's the new law is a little lopsided? It's favoring one side more than the other?
See, I think this present law is fulfilling a constitutional mandate. In that regard, I am talking about Article 39A and Article 41, under which the state is duty bound to provide livelihood and also education, including training. See, I am talking about item 25 of the concurrent list, which talks about education and training. So by this law, the state is providing for training as per the constitutional mandate. And as far as it being lopsided is concerned, I do not think that it is lopsided, because see, it is taking into concern two different constitutional mandates. One is the one I have already talked about, and the second is that the state has to ensure that the youth are not exploited. In that regard, I am talking about Article 42 and 39E and F. So it's not that Apprentices Act, the new amendment, has done away with state intervention. Certain things are to be prescribed.
About the skill part, do you think the law as it is allows skill development to happen, which, as Avinash said, is a mandate of the state?
I think the amendment of the law is come at the right time. It's because today the government has recognized around 32 different types of skills. And if you look at the earlier ITIs and other vocational training institutes, the industry generally feels that the product coming out of that institutes are not really fitting into the requirements of the industry. These skill councils, 33 councils which have been approved by Government of India, are now developing the course curriculum and operational standards, and then empowering the training providers to have the right kind of infrastructure. Now that the Act insists that the programs which apprentices should undergo should be recognized by the government, now that these councils have come into existence, I think it will really help the industry, one, getting the apprentice to get trained in the internationally accepted and industry required skills. So I think it is done at the right time.
Ma'am, a question to you. See, your point is well made, well understood, appreciated. In fact, this was one of the points that was rarely debated in the parliament. You must have witnessed that. Where there is no skill possibility, or where the apprentices were not being taken on because of the legal framework, do you think now a situation has come where it will improve? Industry will start taking apprentices now.
Yeah, well, it's a tricky question in a sense, because we will have to wait and watch. Based on the very recent study that our institute had done on manufacturing sector, we actually find it's only some of the large and medium-sized industries which were opting for apprenticeship. Even that was only about 50 to 60%. So of the mandated coverage. So they were really not taking on the apprenticeship as prescribed or as mandated. So given that, now with this increase, the fact that they can now have a larger number of people as apprenticeship in terms of the proportion, to what extent is it going to be taken on? Of course, there's lots of opening up that's happening, so one would expect that they should take on, precisely also because there's a lot of talk of our not having enough skilled manpower.
Correct.
So we keep talking about the skill mismatch and the fact that we have an unskilled population or not adequately skilled population. Given that, I think it should be something that the corporate sector and the companies should take up.
Avinash, you said is the mandate of the state, is the mandate of the state to fulfill such certain obligations for the employability of its citizens. That is all right, but to what extent is it justified to give a complete free hand to the employer to allow them to hire and fire, one, fix timings as and when they require, what suits the company, also who to recruit, who not to recruit, everything, even the holidays, timings, work hours, shifts, everything goes into the hands of the employers now. Do you see a mismatch?
All right, I understand your question. You are talking about freedom of contract, and in that to that extent you are saying that the workman has been the employer has been given all the cards and the apprentice has been given nothing at all. Yes, to that extent I believe that certain modifications need to be brought, because you see, giving all the cards to the employer will obviously make the field a bit difficult for the apprentices. But please understand in this regard that we had this act since a long time and it was not doing much good.
So it was not serving the purpose.
Either to the industry or the youth.
And on that same point, sir, do you think it is right to allow them all the cards?
Now, because there are certain types of industries which are seasonal. Say, for example, in the case of a garment industry, it is seasonal. We export mostly to Western countries. Now, they have a demand for summer. In winter, they don't have a demand. Now, if I employ about 200 workers because I have a lot of work, now after 3 months, I don't find work, I will not be able to retrench. So, it is not that...
So what you're saying is it is unfair to burden the entrepreneur
Exactly.
with the welfare measures that the state should really take the burden of.
Yes.
That's the point you're
Yeah.
making. Okay.
So-
It's time for us to head into a break. When we come back, we will talk about the removal of penal provisions, which was a deterrent for employers wanting to hire apprentices.
Watch the world come alive in your living room. Defining moments. Momentous events. News Tonight, your window to the world. Every night at 9 p.m.
अंग्रेजी हुकूमत के दौरान हिंदुस्तान में 3 शाही दरबार हुए। इनमें से तीसरा दरबार ऐतिहासिक था, जो 1911 में हुआ। इसमें जॉर्ज पंचम और क्वीन मैरी खुद मौजूद थे।
राज्यसभा टीवी की कोशिश, मुद्दे समाज के।
में बहुत सा विकास ऐसा हो गया जो नियोजित नहीं था, अनियोजित था।
ये डल झील खुद अपने अस्तित्व की लड़ाई लड़ने को मजबूर है।
बात वंचित तबके की।
इन निर्माण कार्यों में महिला मजदूरों की सुरक्षा आज भी एक बड़ा सवाल है, लेकिन अगर इस किन्नर तबके की बात की जाए तो यहाँ कहानी बहुत अलग है।
महरूमियों और सिस्कियों के बीच भी है जिंदगी,
और इनकी बेहतरी के लिए कुछ सार्थक कदम उठा पाते। हौसलों, इनके अज़्म और इनकी मेहनत को सलाम।
देखिए स्पेशल रिपोर्ट सिर्फ राज्यसभा टीवी पर।
Hello and welcome to India's World.
Economic policies are now being literally decided not in Athens.
See, ultimately there is no such thing as a free lunch.
There is too much political stakes in keeping the EU hanging together.
Watch experts debate the relationship of Greece with the European Union in India's World, only on Rajya Sabha Television.
Welcome back. Employers will no longer have to face penal provisions for violations, which was the case earlier. Government has dropped a clause under which employers could be imprisoned for not implementing the law. The Apprentice Act removes imprisonment as a punishment for violating provisions of the Act. The statement of object and reason of the Act clearly states that the major concerns of the employers have been that provisions of the present law is too rigid and to encourage them to engage apprentices.
But this is not the way to give employment to the unemployed youth. This is the totally exploitation of the working class, because they will work just like a bounded labor. They will not raise their voice because they want a certificate from the employer. And under that tension or pressure, they will work up to 12 hours and they will get only stipend. They will not get any minimum wage.
Where it says that the number of working hours can be decided by the employer, I think they should over there clarify that the number of working hours should not for any reason be what has been prescribed as per the Factories Act and the Shops and Establishments Act, or like it says for leave and holidays, the number of working hours should not also be more than what is already there for the other existing employees that the employer is having.
The new law prescribes 18 years as the minimum age for apprenticeship in hazardous industries. The new law removes the requirement for advisor's approval. Earlier, the law stated that every employer should make suitable arrangements in his workshop for imparting practical training to apprentices as per the program approved by the advisor. The new law specifies that training on specific trades can be provided in any institute with adequate facilities. In order to make the apprenticeship more responsive to youth and industry, a slew of suggestions had been received for making changes in the Apprentices Act 1961. The Apprentices Act is the nodal act for training of apprentices in the industry. The act got assent from the President of India on the 27th November 2014. The Apprentices Act 1961 was enacted with the objective of regulating the program of training of apprentices in the industry by utilizing the facilities available with them for imparting on-the-job training.
Government is aiming to create maximum employment opportunities for those who are working in textiles and paramedical sector. Government believes that if the provisions of the Act are implemented in letter and spirit, they will be able to achieve their targets. With camera person Rajdeep, Rajkamal Rao, Rajya Sabha TV.
Earlier, the persons above 14 years could be employed, but now for hazardous sectors, the age has been increased to 18 years. My question to you, Mr. Rao, is they've done away with over-regulation. One, that's the attempt. Second, they've also heeded to the voice of the entrepreneur that, okay, penal provisions were a deterrent for you, so we will be more accommodative, we will drop it, and now it is a fine of 500 rupees for every violation. How important was doing away with this, that is over-regulation and penal provisions, to allow entrepreneurs to go forward and employ more?
So it is like this, the employer should also have to take it in a sense where it is admissible for the apprentice to give the maximum outputs. It is basically a learning process. So during the learning process, the extent of involvement in terms of mental or physical strain is not that of a regular worker. So apprentices are not that they are on the job like a regular worker. So in the case of a regular worker, we give a limitation that he should be only working for 8 hours. Maybe if you are giving a overtime, it should not be more than another 4 hours. And the total number of overtime period in a week is again fixed. But in the case of apprentice, he is not that he is on the job all through. So giving a restriction or like a regular worker is not really fitting into the situation. Only problem is that there may be cases where the employer may exploit it. So it is ultimately.
So what you are saying is, effectively what you are saying is, if you are young, if you are inexperienced, and if you are going in for apprenticeship, you have to be prepared to work harder than what you were doing before, without any protections.
Exactly.
Correct? And in case there are any violations, there should be no possibility of the entrepreneur to be pulled up.
I'll give another example.
Avinash, I bring you on this.
See, as far as the penal provisions are concerned, we must understand that they have become non-substantive. That means the imprisonment part has been done away with. Now, there are few legal implications of making it non-substantive. Firstly, it can be easily condoned. Secondly, the right to counsel is no longer there, because you see, right to counsel is only where arrest and detention is a part of the sentence. And thirdly, right to appeal is not there. So that ways, of course, it has become very lenient. I will not say flexible, lenient, very lenient. And it is serving the purpose of employment generation in the long run. That is all.
Ma'am, your input on both these, on the penal provisions, the leniency that he's said, and also the point of view Mr. Rao has made, that see, these are young people, inexperienced people, they need to work harder, and the difference between apprentices and regular employers.
See, the differences between apprentices and regular workers is well taken, but at the same time, basic human rights and worker rights, or even within Apprenticeship Act, there should be a protection of individuals against certain kinds of exploitation. So that has to be necessarily provided for. So there have to be some defined parameters which it should not go beyond. Apprenticeship, just like any other training, might have certain, some expansion in terms of time and other kinds of things, but we have to take care of non-exploitation.
You were making a point, Mr. Rao.
I would like to say that Apprentice Act is basically for youngsters. I will give a classical example. If a student is appearing for, say, IIT entrance examination, he works for about 18 to 19 hours a day. If a boy of a graduate appearing for a UPS exam, maybe for about 6 months or 1 year, he is totally cut away from the whole world and he works almost 20 to 22 hours. Your apprentice also is something on this situation where when you are trying to learn, you should not give any kind of a restriction on the number of hours. It is for him to get these skills as quickly as possible, especially in the manufacturing. It is not that you have to sit in the classroom and read. You have to work there to get a proficiency in that particular skill. So giving some kind of a restriction on the number of hours.
So basically what you're saying is the fundamentals of the industry, that if you're young, you work harder, and if you are an apprentice, that is, you will have to be prepared to work
for longer
further,
hours.
even if it be at the cost of dropping all protection that was being allowed to him.
Yes.
Moving on, my colleague Raj Kamal Rao spoke to Mr. Alok Kumar, Director General of Employment and Training, and tried to get an insight into the implementability of the new law.
The main spirit behind this amendment is, the key objective is to make it workable and flexible for both for the industry as well as the youth. So the key changes which have been made in the Act through this amendment, first, the industry has been given flexibility to employ, to keep apprentices within a band. Earlier it was very rigid.
The Act has been changed and you have new provisions for your office. So what kind of implementative issues that you have once this Act is notified?
There was a lot of paperwork and compliance and contract approval with the apprentices involved. we have included a facility of a portal in the law itself, and this portal will come up soon. We are working for it, and all the transactions, all reporting will be done through portal. So that's why it has been made very industry friendly. For youth, we have enhanced the stipend. The stipend has now been indexed to the minimum wages of the semi-skilled worker. So it has almost doubled, because we need to attract youth also.
The present government has a prestigious Make in India program. How does this act contribute to government's target in achieving larger employment opportunities for those who are working in textile and paramedical sectors?
So as I have told you, the vocational training or skill development is for the ultimate outcome of the employability and employment. And we have done a study which has indicated, which has concluded that employability of the apprentices is the highest. The employability of the apprentices is around 67%. It is around 60% for ITI students. And for general engineering graduates, employability sometimes is around 25 to 30%. So by expanding apprentices scheme, we are directly addressing the desired objective of employment and employability. That is, it fits in very well in that strategy.
Thank you, sir and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Rajya Sabha TV.